What happens when a man spends 6 years in prison without being convicted, simply because the law made bail almost impossible to get? Today, the Supreme Court of India answered that question. And in doing so, it delivered a message that every court in this country needed to hear. The case is Syed Iftikhar Andrabi versus the National Investigation Agency, JAMU, Special Leave Petition Criminal 1090 of 2026, decided on May 18, 2026, by a bench of Justice B.V. Nagarathna and Justice Ujjal Bhuyan. The petitioner is a resident of Handwara in Kupwara district of Jammu and Kashmir, who was arrested by the NIA in June 2020. The NIA charged him with funding terrorist organizations, Lashkar-e-Taiba and Hizbul Mujahideen, through the proceeds of heroin trafficking across the border. Andrabi was charged under the Narcotic Drugs and Psychotropic Substances Act, the Unlawful Activities Prevention Act, and the Indian Penal Code. Under Section 43D5 of the UAPA, bail is an almost impossible standard to meet. The court must be satisfied that the accusation is not prima facie true. The prosecution only needs to clear a low bar to keep you locked up. The NIA court refused bail in 2024. The High Court refused bail in 2025, acknowledging 5 years of custody, but saying the charges were too serious. By the time the matter reached the Supreme Court, Andrabi had been in jail for over 6 years, without a single day of trial completed. The central question before the court was whether prolonged pretrial incarceration under the UAPA was itself a constitutional ground for bail, regardless of how strong the prosecution's case appeared on paper. This had already been answered in 2021 by a 3-judge bench in Union of India versus K.A. Najeeb, which held that Article 21 of the Constitution, the right to personal liberty, does not stop at the gates of the UAPA. When trial is delayed indefinitely, bail must be considered, period. The problem was that 2 subsequent 2-judge bench decisions, Gurwinder Singh in 2024 and Gulfisha Fatima in 2026, had quietly tried to walk that principle back. The Supreme Court was unsparing. Justice Bhuyan's judgment states, and I quote, "A judgment rendered by a bench of lesser strength is bound by the law declared by the bench of greater strength." Judicial discipline mandates that such a binding precedent must either be followed or, in case of doubt, be referred to a larger bench. A smaller bench cannot dilute, circumvent, or disregard the ratio of a larger bench. The court disapproved both the Gurwinder Singh and Gulfisha Fatima judgments by name. It held that the 2-pronged test introduced in Gurwinder Singh, which required an accused to prove no prima facie case exists before bail for delay could be considered, was constitutionally dangerous. The court said, if that test is accepted, the state only needs to maintain a low prima facie threshold and keep the trial dragging on forever, turning pretrial detention into punishment. The bail plea was allowed. Andrabi walks free after 6 years. The takeaway for practitioners is significant. K.A. Najeeb is now firmly restored as binding authority. Every bail application in a UAPA case must squarely address delay in trial as a standalone constitutional ground. And every trial court and high court must think twice before reflexively invoking Section 43D5 to deny bail where trial has stalled for years. The court also put on record that UAPA conviction rates nationally are around 6%. In Jammu and Kashmir, under 1%. Years in jail for charges that almost never result in conviction. The court saw what that means. It said bail is the rule even here. For the full legal analysis of this judgment, visit pvlegal.in or subscribe to PV Legal's daily newsletter. I'm your host. Stay legally informed.